Last month, the Environmental Protection Agency, EPA as we know it, their administrator, Scott Pruitt, issued a directive to all agency employees that prohibits the so-called sue and settle process. This is good news for good government. Most of us here are familiar with the term sue and settle. These are tactics whereby the EPA has in the past resolved certain lawsuits against it through agreements negotiated behind closed doors with politically favored interest groups. As we saw under the Obama administration, some of these agreements committed the EPA to take far-reaching regulatory action, all without an adequate opportunity for those people most impacted to have a seat at the table, as would normally be done through the regulatory process. Today, I come to the floor to applaud Administrator Pruitt's leadership in working to end these tactics, which make a mockery of laws that Congress put in place to ensure transparent and accountable regulatory process. The common sense reforms outlined in Administrator Pruitt's directive will, no doubt, help restore transparency and accountability. And these reforms should stand as a prime example for all federal agencies to follow. Accordingly, I call upon President Trump to use his full authority through executive order to ensure that similar reforms are adopted across the entire bureaucracy. Regulatory decisions that affect key parts of our economy should be made in an open, transparent, and consequently accountable manner. But as we've seen in sue and settle, Washington bureaucrats, and for the special interest that special interests have, these bureaucrats and their interest group pals would prefer to do things their own way has been done through sue and settle. It works like this. First, an interest group sues a federal agency, claiming the agency has failed to take regulatory action required by law. Through the lawsuit, the interest groups seeks to compel the agency to take action by a new, often rushed deadline. These plaintiff interest groups often share a common regulatory agenda with the agency that they sue, such as when an environmental group sues EPA or the Fish and Wildlife Service. Instead of challenging the lawsuit, the agency and the interest group enter into negotiations behind closed doors to produce either a settlement agreement or a consent decree committing the agency to take regulatory action. No transparency, no accountability that you get through normal regulation writing. Noticeably absent from these negotiations are the very parties who will be most impacted, such as farmers, manufacturers, or even our 50 states themselves that will be charged with enforcing some of these regulations. In 2010, for example, an environmental interest group sued the Obama administration EPA to force the agency to revise certain wastewater regulations. Wouldn't it be nice to have the people that are affected by those regulations to be involved in the process in an open way, the way the Administrative Procedures Act is designed for? Oddly enough, the same day that the lawsuit was filed, the plaintiff's interest group submitted a consent decree already signed by the EPA, which committed that agency to take prompt regulatory action. Now, such a scenario should raise serious questions about how truly adversarial these lawsuits and negotiations really are. To add insult to injury, regulations that have resulted from sue and settle tactics impose tremendous costs on the American economy. According to the American Action Forum, from 2005 to 2016, 23 sue and settle regulations resulted in cost burden of $67.9 billion, with $26.5 billion in actual costs. 16 of the rules impose paperwork burdens on American job creators of more than 8 million hours. Now just think about that. Nearly $70 billion in regulatory costs were imposed on American business owners, manufacturers, farmers, and probably taxpayers, all without due regard for transparency and the normal rulemaking process required by the Administrative Procedures Act. Decades ago, Congress enacted that Administrative Procedures Act for the sole purpose to ensure transparency, accountability, and more importantly, public participation in federal rulemaking. The APA has been described as the citizens' regulatory Bill of Rights. A pillar of the Administrative Procedures Act is the notice and comment process, requiring agencies to notify the public of proposed regulations and respond to comments submitted. Transparency, in other words. Rulemaking driven by sue and settle tactics frequently result in reprioritized agency agendas and rushed deadlines for regulatory action. This renders the APA's notice and comment process a mere formality. It deprives regulated entities, it deprives the states, and most importantly, it deprives the American public of sufficient time to have any meaningful input on final rules. The resulting regulatory action is driven not by the public's interest, but by the special interests' priorities. Sue and settle tactics also help agencies avoid accountability for their actions. Instead of having to answer to the public for controversial regulatory decisions, agencies' officials will simply point to the fact, well, the court ordered us to do it. And they will say that their hands are tied, when really they welcome that process. The American people deserve better. But don't take my word for it. The Environmental Council of States, a national nonprofit, nonpartisan association of state and territorial environmental agency leaders, adopted a resolution in 2013 entitled, quote, "The need for reform and state participation in EPA's consent decree which settle citizen suits," end of quote. It provides, and I quote the rationale behind it, quote, "State environmental agencies are not always notified of citizen suits that allege U.S. EPA's failure to perform its non-discretionary duties, are often not parties to these citizen suits, and are usually not provided with an opportunity to participate in the negotiations of agreements to settle the suits." So end of quote. The Environmental Council of the States further resolved that, quote, "Greater transparency of citizen suit settlement agreements is needed for the public to understand the impact of these agreements on the administration of environmental programs, end of quote. Obviously, I agree. We need more transparency, more accountability, and more voices at the table. In other words, the public's business ought to be public, not some new regulation agreed to behind closed doors. I'm happy to say that this administration is working to accomplish that. Thanks to Administrator Pruitt. In his own words, quote, "The days of this regulation through litigation are terminated," end of quote. This directive puts a swift end to sue and settle tactics by this one agency, the EPA. It does so by adopting common sense reforms to promote transparency and the resultant accountability, and most importantly, public participation in the regulatory process. It requires the publication online. It requires the publication to be online of notices of lawsuits filed against the EPA. It requires the EPA to reach out and notify any states or regulated entities who will be affected by the lawsuit. It requires the EPA to seek the agreement of any affected state or regulatory entities before the agency can enter into a consent decree or settlement agreement. Further, it prohibits the EPA from entering into any consent decree or settlement that converts a discretionary duty of the agency into a mandatory duty to issue, revise, and amend a regulation. Most importantly, it requires the EPA to post online for public comment any proposed consent decrees or settlement agreements before they're entered into by the court. These and other reforms in Administrator Pruitt's directive mark a very strong step towards ensuring that states and American job creators and the public at large have a seat at the table when regulatory decisions are made, as exactly why Congress passed the Administrative Procedures Act. Before I close, I'd add just one more thing. Earlier this year, I introduced the Sunshine for Regulatory Decrees and the Settlements Act. This bill would make permanent the very types of reforms outlined in Administrator Pruitt's directive, so if it becomes law, it can't be changed at some later date. In other words, it would ensure that future administrations can't simply roll back the great work of Administrator Pruitt is doing through this directive of his. I'm pleased to hear that the House of Representatives just passed the companion bill introduced by Congressman Doug Collins. We'll continue our work to build bipartisan support here in the Senate for this common sense decree. But today, I urge President Trump to move forward with an example set by Administrator Pruitt, because Administrator Pruitt is draining the swamp through this process. And the president loves to sign executive orders. He'd probably do more good draining the swamp, producing an executive order like this than almost any executive order he could do. There is simply no reason then why these reforms should be limited to just the EPA. Transparency and public participation are core elements of a more accountable government. Pretty simply stated, they're part of the process of representative government, where people make the laws and where administrators carry out the laws. and not where something's done behind closed doors because some special interest wants something, or because the agency is begging to do something that maybe somebody doesn't want them to do. To get it done and do it behind closed doors, just work it out the way we want it, not necessarily the way it would be done if people were participating. I applaud Pruitt's directive. I urge the President to promptly see to it that similar reforms are implemented across the administration. So a third time today, President Trump issue an executive order to all departments to do what Administrator Pruitt has done at the EPA